Hello, my name is Jamie Gary. I am the owner of Vision Consulting LLC. We are a full service legal nurse consulting firm and the host of the Attorneys Resource Conference. The Attorneys Resource Conference will be taking place in Grand Rapids, Michigan, August 11 through 13, 2026. This conference is designed to bring a diverse group of individuals together in the areas of law, healthcare, and anybody working with medically related cases. The goals are to improve strategy and case litigation, to improve professional practice, and to improve your ability to identify and mitigate risk. You will see in the bottom corner of the screen, there is a QR code, or you can type in attorneysconference.com. Go there and make sure that you have a seat at this event. Today, I would like to welcome Attorney William Azkoul. He will be presenting at this year's conference, and I would love for you to give our audience a little background about yourself, who you are, and what you do.
I'm Bill Azkoul. I am a principal at Gruel Mills, Nimson Pileman. I've been here for 13 years. I specialize in personal injury, wrongful death, medical malpractice, bodily injury, commercial litigation, and mediation. Prior to the last 13 years, I was in private practice for myself for 27 years in a variety of litigation practice areas.
You have a wonderful background. I'm
Thank
looking
you.
forward to getting to know you at the conference.
Thank
So,
you.
what drew you to accept our invite to present at ARC 2026?
Jamie, your invitation to speak was the first step. I did some research on the Attorneys Resource Conference, and I discovered that you will focus on a variety of medical legal issues. I'm passionate about excellence in advocacy in civil cases and in bodily injury cases. I've given that a lot of thought. I've spoken on it previously, and for that reason, I decided to accept your invitation.
We're very glad you did. So, people are curious. Are you able to give them a little snapshot, just a sneak peek about your presentation and what they can expect to learn from you?
The topic of the segment will be the importance of preparation for one's deposition. So, in bodily injury cases, the injured party will most definitely be deposed, as will a provider if a provider is a party in a case like a medical malpractice case. Witnesses who treat patients often are deposed as well. So, what I would like to do in this segment is to discuss what is not only adequate preparation, but excellent preparation. I believe that there's a need to raise the awareness of just how important it is to be fully prepared for the deposition. So, what I typically do is I start with a letter to the client and I set forth the criteria of what preparation is going to look like. I meet with the client not once, but typically 2 or 3 times. We go over a variety of topics, and the topics might surprise you. We talk about the psychology of communicating in an adversarial proceeding because communication principles are very different in that setting as opposed to the setting that you and I live in 99.9% of the time. So there are differences. We talk about how to adequately answer questions on direct and cross-examination. We talk about whether it would be prudent to review pleadings or documents that are relevant to the underlying issue in the case or not to review those documents. We talk about credibility. And many people think, well, credibility is important, but there's not a lot you can do to showcase the right type of credibility. And that's a myth. So we really break it apart. We go through mock exercises questions and answers together. And I usually, when I do that with clients, I get them going with some of the easy background information. And then we get into the nitty gritty of the elements of the claim or the defense that I expect are going to be challenging, the ones that might compromise the outcome that the client is looking for. So we go through mock exercises, just a variety of different ways, so that in the end, there is absolutely no surprise. By the time this deposition is done, the client should not be surprised by anything. When that happens, I know that I've done my job well. But I think that lawyers need to understand the importance of the correlation between excellence in advocacy at the deposition and case outcomes. There is a direct correlation.
Mhm. As a nursing expert who does testify, I'm excited to sit in your presentation. I'm sure there's a lot to learn. So, why is this topic so important, and what is the risk
Mm.
if this topic is not addressed?
When I started practicing law, 5% of all cases, civil cases, were resolved at trial. And that was a long time ago. Now, less than 1% of all civil cases are resolved at trial. That means that over 99% are either settled or they're dismissed prior to trial. So the old saying, cases are won in the courtroom, doesn't apply as much nowadays. I believe the better saying and the more accurate saying is that cases are won or lost in the conference room. And again, if you're a party in a lawsuit, or if you're a treating provider and the bodily injury status of the plaintiff is at issue, you can almost bet on the fact that you're going to be deposed, especially if you're a party. So the risk of not giving attention to the importance of excellence in your deposition testimony and advocacy is that mediocre performance, mediocre testimony almost always translates into substandard case results. It just does. And as a mediator, I see lawyers and their clients in my office dozens of times every year. And I have a sneak peek of what happened in the course of discovery prior to their getting to me. And I'm seeing too much of mediocre deposition advocacy and testimony and not enough of excellence. And so that tells me that there's a need to spend a little bit of time and gather the people that are going to be involved, the participants, the lawyers and providers, and have just a session that really just focuses on this issue.
Mhm. So, getting all of those people together as the attendees for your session, how do you want them to think, feel, or act differently as a result of your presentation?
I want them to expect that they need to view this aspect of the case as an extensive preparation that will require a tireless effort. This is not something that you can just give a half hour or an hour to. This takes a lot of planning, and it takes planning with their advocate, with their attorneys. I want them to understand that if they are well prepared and have thought of all of the types of questions and the concerns, those aspects of their case that might derail the case, that might end up providing for a less than ideal outcome for the client. I want them to have very carefully thought through those issues and received the advice of their legal counsel and gone through practice questions and answers so that they can get through that aspect of the testimony and focus on what is most important in their case or their defense.
Mhm.
There are aspects of their case or defense that will heighten the prospects of a great recovery. Whenever a plaintiff can be well prepared to talk about the impact that their injuries, that their residual limitations have had upon their life, the case translates from a good case into a great case. It just does. I want them to realize that good deposition testimony does not just happen. I want them to realize that it's not the facts that will govern the outcome of the case, solely the facts. It's not the applicable law, but the credibility of the parties is critically important. If you ask many jurors after a jury trial, what's the one standout for you? They're not going to tell you the story. They're going to talk about how they felt about the plaintiff. They're going to talk about whether they thought that the defendant was telling the truth. So depositions and credibility are intricately related.
Mhm.
This is the lawyer's one opportunity with the opposing party in the case. It's his one time to ask him questions or get to know her. And so what I want them to realize is they need to take, both the attorneys, their staff, and the providers who are going to be testifying, need to take this aspect of the case very, very seriously.
So, in everything that you just shared, what is the one thing that you feel is most misunderstood about this topic?
Well, I don't want to be repetitive, Jamie, but there's not a lot I can do as an attorney to prepare my client because the medical records have already been written.
Right.
I've already had eyewitness testimony on what happened. And so I see lawyers spending 15, 30 minutes preparing their clients for depositions, and I see it a lot. It should be a 1 to 2 week process.
Okay.
And it should be a process that lasts several hours. The misconception is there's not a lot I can do with the record that's already been established. And I'm here to say that your client's deposition may be the one thing that prevents the court from granting summary disposition. It may be the one thing that makes this so appealing to a potential juror that you get the attention of an adjuster or a risk manager, and they take another hard look at the case, and they take another hard look at what their settlement reserves or parameters were up until that time.
Okay. So, who do you believe should be in the room for this presentation?
Lawyers and their paralegals, providers at all levels, okay? Nurses, mid-level providers, doctors, hospital administrators, risk managers, adjusters. And whether you as a lawyer dabble in bodily injury litigation or specialize in it, I think that this conference and I think that this segment would be very appropriate and very beneficial.
I can see that. And I can see a lot of passion behind the subject that you have to offer the audience. So, thinking about your own experience with ARC 2026, what are you most excited about?
You know, we don't have many conferences in Grand Rapids where medical and legal professionals come together. Um, Back in the 1950s and 60s, the doctors and the lawyers in Grand Rapids got together for regular softball games. There was a rich relationship between the two. And really, we have few opportunities now for these two communities to come together. In the divisive world we live in, we hear more about divides between the medical community and the legal community. I think this is going to be a great opportunity to bring our two professions back together. But we're doing so in downtown Grand Rapids. So the Bob is, I'm looking at the Bob right now. It's right outside my window, down 8 floors. It's in the heartbeat of downtown Grand Rapids. This time of year, we're going to be in August of 2026. Downtown will be buzzing. There'll be a lot of activities. We have a new amphitheater that will be opening in the spring, just down the street, a short walk away. There'll be a lot going on, and I
There'll be
think that those that are coming in from out of town are going to have a real treat. But just for all of those reasons, this is a conference that I hope that our colleagues in the medical community and my colleagues in the legal community will attend.
Thank you. We are hopeful for that too, and we're grateful to you for giving your time and your willingness to present. I want to thank you for watching this video. If you don't have your seat for ARC 2026 yet, please take the time right now before you close out the video to click on the QR code or go to attorneysconference.com. Make sure you are registered for all of the amazing presentations, the interactions, the networking, everything that we have to offer you, and we look forward to seeing you there.